Sarah Boone, she's got a reputation of running with the law, but not for her beauty, she has done hit a wall. She's known for something that'll make you cringe. Spent the night drinking, just a bit of a binge. Sarah Boone, writing letters from herself, locked her boyfriend in a suitcase, so what the hell? With a twisted sense of humor and a heart so cold, she recorded his cries while she laughed and rolled. Now Sarah's standing trial, writes letters and pleads. She says no attorney can satisfy her needs. She's on her own, defending her crime. With the 4 years gone, she is just wasting time. Oh, Sarah Boone, the talk of Winter Park, sending letters from jail, she's making her mark. Locked her boyfriend in a suitcase, so what a tale. Laughing as he cried, recorded it without fail. Oh, Sarah Boone, the talk of Winter Park, sending letters from jail, she's making her mark. Locked her boyfriend in a suitcase, so what a tale. Laughing as he cried, recorded it without fail. The courtroom's buzzing, the tension's high. Sarah Boone smirks, won't bat an eye. She's a half-wit that'll make y'all scratch your head, even when facing charges of making a man dead. Sarah Boone, the jokes are behind bars, writing letters from jail, reaching for the stars. Locked her boyfriend in a suitcase, the ultimate prank. With a bad sense of humor, then continue to drink. Now it's time to dig deep into this harrowing tale. Sarah Boone, the prankster who did not fail, locked her boyfriend in a suitcase, let him meet his doom. But we'll always remember her name, Sarah Boone. But we'll always remember her name, Sarah Boone.
I love a buttered biscuit.
Good evening, everybody. How are you? Oh, my Lord Almighty, do we have an interesting one for you today? Oh, man. Good to see you, Daniel Berry, Sports Highlights. It is wonderful. Hello, Heidi Bruce. How you doing? T42. I love it. Love it. We got T for 2 hanging out, just being absolutely chilling. Says it's going to come back later. Look forward to it. Look forward to it. Oh, we've got some good stuff for you tonight. Ooh, 58 pages of torture. oh, gotta love it. Gotta love it. And I've got some really interesting stuff that's going to be happening. You need to check in next Monday. It's going to be something new. It's going to be something fresh or old and wretched, one of the two. But next Monday, it is going to be something that you want to check in on. And I'll be promoting it as the week comes along. Good evening, Phoenix. Good evening. Good to see you. Good to see you. Yeah. We've got a very fun thing planned for Monday. You just will have to stay tuned. And it is going to be something that you have not seen on this channel yet. And it's going to be something well worth checking out. Very well worth checking out. It's going to knock your socks off. Let's put it that way. I'm looking forward to it. It's going to be so much fun. But what we have tonight is we have some letters from the Saraboons. Have some more letters from the Saraboons. Oh boy, it gets crazy. It gets crazy as all get out. Oh yeah, 58 pages of crazy. 58 pages of crazy. What could be better than 58 pages of this? As Sarah Boone would say, Honorable Judge Gray Nick. Ongoing 5 years. ... Why can't I ... use my constitutional rights? Am I the only one who cares about the ongoing violations of... have a bond? Why can't I have all my medical records? Why can't I have all my digital evidence and discovery? Why can't I have all my paperwork, my notes, letters, pictures, everything of mine returned by a former attorney? Why can't I speak to my investigator? Why can't I have a complete download of my phone? Why can't I have any of my witness lists? Why can't I give any insight, understanding, clarification, truths about my case, especially to my attorney? Why can't I be listened to by anyone, especially my attorney? Why can't I be respected for who I am truly, especially by my attorney, and not be disrespected for the mutated, malicious murderer all the world has falsely, incorrectly created and believes me to be? Why can't I be treated fairly, lawfully, and be protected by the justice system? Why can't I properly, rightfully, completely defend myself? Why can't I see all and know the same as the world can and does, including my attorney, from all the phenomenal, non-permissive amount of my entire case being available online globally before my trial? And most important, before I have seen myself. What doesn't anyone know already about my case? How about my side in everything? Everything. Why can't I be correctly understood that I am not the problem for reasons I am on my malappointed by court attorney number 8? Why can't I see my letter 7/21/2023? Why can't I say what I want and should, but all the world can and say it all wrong and warped? Why won't my attorney give me an honest answer? Why won't he show me everything she says? Oh, she says. Why won't she show me everything she says she has and finished reviewing for my case, but without words, but withholds from me after I ask repeatedly for and about Why won't my attorney give me an answer other than I'm putting this to rest? That's not necessary. Or I'm having this conversation with you? Why is my why won't my attorney grant me access to anything I asked for and in and about my case? Why won't my attorney, like the detectives in my case, stop putting words in my mouth? Why won't my attorney tell me what's going on in my case? It's been well over 100 days she has been my attorney, and I still do not know anything. Ongoing 5 years. Why can't my attorney answer any of my questions? Why can't I ever ask? Why can't my attorney ever ask me any questions? How can she supposedly know everything she needs to know from what she's been told, heard, read, seen? Why can't my attorney reassure they're on my side for me, not against? Why can't my attorney? Why have I already been judged in court of public opinion? How did that happen? Why have I been what? Renounced by anticipation and condemned before my predicted prescribed tile? I don't know, she said. Why does my attorney and all the world think my case is already over? Your Honor, during our first introduction at my last withdrawal of court-appointed attorney number 7, Hobson, you stated to me your involvement with any of my letter I write. I'm still going to write my letters as conductively as they are to the world where all my potential jurors are located. And this is the only way anyone, including yourself, knows the very necessary insight to my continued disadvantages, hindrances, impediments I'm still experiencing on top of the new spurring new intentions to write. The race to the pulpit is unfair, and it's important to me that you are aware and understand what transpires when the news cameras are off and we're all between my status hearings. Too, as so many of the advantageous embezzlers, racketeers, mindless and lemmings, and just altogether mean people can use their freedom of speech, not knowing me in any way other than what's being said by all the other mean people. Oh, they're so mean. They're so vicious. And being said incredibly incorrectly. So, can I, as the compelling, annoying detectives in my case, Corporal had to falsify documents and lower his gun for me to see. I'm sure, are you familiar with all, after watching all my plastered, highly misconstrued, over 30 plus million views just on one site interviews in which they both repeatedly attempt to feed me their incorrect, incomplete, hypothesized opinion by stating to me everyone has their limits. This seemingly endless point of perpetuity of nonsense and lawlessness still growing, and I very much wanted to advance to the next level. After ongoing 5 years now, a genuine concern limit has been reached. Why am I still not being included in my case? How much more of my case and self is being added hourly, especially after this letter gets loose to the internet, increasing the mass infection and destruction of my hopes to have a fair trial. Anything fair, my side foremost, and wondering now if my attorneys drank a punch like everyone else. Oh, woe is me. All aforementioned reasons and so many more for this letter to be written, hoping to deter some of the unfair, one-sided finger pointing, corruption and malpractice being directed at me only by those in the justice system who are trying to deflect the shame and shock from me, fearlessly challenging the status quo. And it must be so because it's in my face on the computer. And it's at the same time on my boob tube television, brainwashed followers of disbelief, conformity, and greed, trying unsuccessfully to make my life by character assassination seems worse than theirs. No, too, when anyone points their finger, and impolite. And 2, 3, point back at you. How many tried it to see? Oh, the finger wagging in my face. Put the stone down, as there will be no casting of anything today except maybe for the role of my part for all the pre-conclusioned documentaries and crystal ball real life oratories of the true crime incorrectly formulated from anyone supposedly knowing me and judging who they think I am. What really happened, it is going to futuristically. Mm. MJ, how you doing, girl? Good to see you. Hope you're doing well. Yes, we have an interesting one. Sarah Boone. Crazy, 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 crazy. Remember, 3-point back. Soothsaying is not a job. To sum it up, in the words of my attorney, after I told her to Google me, she stated, "There's a lot." To sum it up, in the words of myself, the defendant, stated to my attorney after the stake that to me, what can I see? How much longer do I have to wait? Or how many attorneys must be withdrawn? Oh, how many roads must a man walk down? Have to wait, or how many attorneys must be withdrawn for me to be included in my case and be included more than just the world presently is? This is my case in every aspect, every single aspect. Oh, this is good. See all my aforementioned ongoing 5 years questions. I'm still waiting for an answer. Just waiting. I'm holding tight, waiting those answers. None are forthcoming. They're not there. Also, I want to make it known I walked out on my attorney in our last meeting due to her unwarranted, informative, unprofessional, snotty attitude and her untruthful answers to my questions and beyond. The retarded, vicious circle. We even imagine we meet as a waste of time. And I'm saying that being in jail with supposed endless amounts of it. How she treats me is extremely prejudiced, hostile, and unconstitutional. She is very frustrating. One, to balk or defeat in an endeavor to induce feeling of insecurity, discouragement, or dissatisfaction. And 3, to bring to nothing. So much I presented my solution in order to coexist with and work together in a hopeful, progressive, positive, appropriate manner. I added pretend judge to our interactions so she could calm down and ease up on her condensation, offensive demeanor, and obvious prejudgment. She seems like everyone else, not to remember I am innocent until judged. She treats me as if I am not. Feel the pain. After my introduction and explanation for with pretend judge in the room or on the phone, I am trying to help her understand how she is making herself extremely unwelcoming. Shame on her. I want to welcome her. She's making herself such that she can't be welcome. When in front of a real judge and in the courtroom, it is how she should treat me, her client, at all times. I should not have to invent pretend judge in order to be, and I am not at all wrong for wanting to be respected, no matter the outcome. I am innocent until adjudged otherwise. My attorney, everyone's should be fair, unbiased, trustworthy, honest, supportive, informative, protective, automatically, and I should feel secure, highly confident, proud in her representing my life. I do not, and have said to her many times regarding her monumental disbelief in me in my case, which I believe contributes greatly to her attitude towards me. I am hoping by this letter she will pick up the sword of injustice and fight alongside, not against me, as so many have already done. Overwhelmed, weak attorneys prior bowed out ungracefully and crept away from the battlefield. So unsuccessful. No unsuccessful. They're a disappointment. It's such a disappointment. My case, bizarre, unknown, different, ignorance, misunderstood, unfair. This does not mean my case can't succeed. And now, more than one way. While everyone continues to ring their bells of malevolence, I am ringing mine of hope, honor, possibility, boldness. I am not a murderer. The justice system should equal fair faith, trust, respect, innocent until and if adjudicated. Otherwise, 3 point back. Sarah Boone. Confused cat meme. Yes, thank you. Oh my God, this lady's bonkers. Oh, the pain. June 4th, 2024. Getting into the meat of this one. Video visit 12 minutes. I'm back. Dang, tech malfunctions again. Yeah. Kickboxing mom, how you doing? In addition to my previous letters intended for hand delivery on 6/7/24 at my status hearing, today my attorney made a video visit to go over everything I've been asking her for and have also sent to her personally in 2 letters, 520 and 525, all on the public video visitation box were on both sides of me, less than 5 inches away from my visit. Other inmates were having their visits also. It's so crazy. There were people having their video visits besides me. That's so crazy. I have explained to my attorney numerous times previously in writing and verbally that despite the noise level, I do not in any way feel comfortable having in-depth private meetings regarding my entire criminal case on the visitation box where there's no privacy whatsoever and held in an open bay dorm with more than 62 other interested all ears inmates. I mean, I can't even touch myself in private. I cannot fully participate, if at all, from the entire dorm, officers included, trying to participate also in my case. As always, my attorney did not listen or care after I repeatedly tried reminding her of my unsecure environment. Barking at me, I can listen or not, still going over, speaking, and not at all allowing me to respond. She's telling me how it's going to be, and she's not listening to me because I'm telling her that's not how it's going to be. You got to listen to me, my attorney. Why aren't you listening? You got to pay attention to what I was saying. If you isn't listening, they might as well just fire you. Get fired. After repeating to her over and over and over while she's beginning to speak louder and over me, still to please schedule an in-person meeting where all can be discussed further privately with no success of being heard. I disconnected the visit telephonically. She is uncooperative. She's impossible. See the previous letter or ask her for a copy of the two I sent her. I was trying to remedy or lessen before sending this to you, your honors, and not having to include. Now it's a race to the pulpit. Good to see. Yeah, she's on fire. My question, please. Who acts like that and still able to call themselves a professional? The visitation box is primarily for family and friends to connect. And if it's a result from an attorney, reminders, notices, quick questions, not high-level confidential case information. It's confidential information. It's not like they're not going to find it in the first place. She, like other former attorneys who always blame their dysfunctions on me, said, you don't like the answers I give you. What answers? See pages 1, 2, and 3. I am not the problem, except that I want to and should be treated fairly with respect, acting more professional than the paid. I've been doing this for over 40 years, professional. After so long and all the experience, common courtesy, customer service, and listening skills should have been acquired. All attorneys, do y'all remember why you even wanted to be one? Remind yourselves. Sweet cheeks. You gotta remind yourselves. No one listens. And I work on it works in everyone's favor but mine that I am a murderer, stuck in jail so they can pin on me. They're uninterested, unconstitutional, unmotivated, hopeless. They're going to believe me over her. Haughty attitude. I'm not wrong for not thinking less of myself because everyone else has and does. This presents attorney foremost. The justice system expects me and other inmates, aka clients, to accept this subpar, nonchalant, hypocritical, next on the list attorneys they keep aimlessly throwing darts for and may appoint praying they don't withdraw. Mo raid. Woo! And let me tell you, it's good seeing you. Hey, Vival, how you doing? Mo Raiders, welcome to Raiders. Everybody, welcome to Mo Raiders. Make sure you hit that like, make sure you subscribe, make sure that you hit that like button on Mo's as you were leaving. Make sure that you're subscribed to her as you are coming in, because there is nothing like coming in here. Because I will tell you right now, when you come in here, you come in as hard and as fast as you possibly can. If you're not coming in hard and fast, then you're just not coming hard.
Woo! Wee woo! Wee woo!
And jobs for all. Nope.
Yes.
Good to see you this evening.
Good to see you. Oh my gosh. How many more? She's going to have a New Testament and an Old Testament.
Mm-hmm. Mm-hmm. Oh. Just getting her voice down is really hard because I've heard her speak a couple of times, but I just don't have the gentleness to my voice.
It's the you have to put yourself in, you are only hearing Sarah is great, Sarah is great. And then if you just loudly hear that in your head the entire time, you can summon up the self-regard of a giraffe, and just be happy. But this woman is insane, and I feel bad that I'm so excited that she's representing herself because it is going to be a poo show. And, as much as I make fun of Jorge for being her fun sized boyfriend because he was a
It was a pocket
short,
rocket.
yeah, his family is going to have to deal with this absolute Darryl Brooks on steroids stupidity. And
For the next few months.
yeah, so it's not like I have a timer on my phone or anything, but I may have a timer on my phone or anything.
Oh yeah, I've got it set. I am so covering this trial. I'm just
Oh yes.
I can't do anything but
You're
it
like,
is
wife, I can't work. Miss Shizzy, I'm gonna have to take all this time off. The world needs me.
yes, they need me. If I'm not in trial myself, because I got a jury summons today.
Just tell them you comment on trials. I'm
That's
sure
all I
they'll
have
let
to do.
I'm
They'll
sure
say, "Do you have any opinion on whatnot?" I have lots of opinions. Y'all can burn. Justice system is so skewed. No, actually, I'd probably be very. I'm not going to lie. I'm not going to lie, but I will say that I do, have a show.
Yeah, I mean, I think that we'd actually do a better job because we understand legal shenanigans, not to the
Mhm.
point, only to the point where we could be very dangerous.
Oh, well, this is where we're at right here. Let me know if this is too loud. I have not fired by any attorneys appointed in my case. For me, expecting the highest equal standards possible for wanting the absolute best outcome in my preposterous mismanaged case.
And representing myself is not capitalized an option. As for both judges have now threatened me with from being outspoken and intelligent in all my observations of the ongoing abuse that I am experiencing, I have no new experiences from it always being the same. Quote, blame Sarah Boone. I refuse to be moved in wanting respect, no matter who everyone thinks I am. Clarity, inclusion, honesty, and professionalism. God,
And
what is
another great reason not to have my case meetings on the public visitation box is my personal confidential inmate information, such as visitation list 2020, 2023, with names, etc., my interactions with inmates and the officers, what I eat, when, and my personal jail calls also being thrown online? For what? To hate me more or try to get others to because I don't eat breakfast or because I know some Latin special meat have short hair, my penmanship is nice, or because I'm not getting fat and sleeping all day, but rather fully applying myself. I'm fighting still, making everyone upset from not having to fabricate, enunciate, splice, edit. The word apparently knows all.
What is next? How many times do I have to go to the bathroom and what function I perform? No one knows anything, nor seems to uh, want to from being comfortable in their corruption and striving to be on top with ratings, web hits, and money. My case details, if anyone forgot. And if you think about it, all that keeps getting plastered, plagiarized, posted, and poked fun of. Hi, Sarah, sweetie, it's me. Yes, except plagiarized because I just read your thing. Now you have plagiarized dictionary or Webster's dictionary a whole lot. Is all in my favor, proving myself right about all the mindless lemons, shut ins, and the justice system advantageously abusing and profiting from everything in my case slash cases before my trial and before I've seen.
Please be sure to read my attachment for FRPC Rule 3.220 in E, restricting disclosure. Am I the only one who thinks of these things? When can I win? If anything, it's coming. I'm not the problem. And if anyone were to slip on my slides, I have to experience, tolerate, deal with any of what I have. Would bravely be doing the same. Don't knock it till you try it. 3-point back when you're pointing the finger at me. Race to the pulpit. Again, always. Seven.
All right, is anyone going to inform her that a pulpit is in church and she would be rushed to judgment or, that kind of thing, but it's not the pulpit. The pulpit is where you preach from.
Well,
I feel
it's
like,
not. It's also not adjudged. It's adjudicated.
well, I have been reading a lot of her letters, so it's adjudged now.
I'm adjudged. I need to be adjudged. West Florida
West-
statute annotated. Florida Rules of Criminal Procedure 3.220 of the discovery.
Notice of discovery. After filing of the charging document, a defendant may elect to participate in the discovery process, provided these rules, including the taking of discovery depositions by filing with the court and serving on the prosecuting attorney a notice of discovery, which shall bind both to the prosecution and the defendant to all discovery procedures contained in these rules. Now, Shizzy, now
Yes.
I'm spitballing here, but do you think that a practicing judge who's maybe done this for 20 odd years could have these rules?
Well, maybe, and they are following the rules of discovery. Maybe that's already been happening. She just doesn't get informed of every single little step that the attorney takes. I'm taking a poop now, Sarah Boone. So, I'm taking a lunch
Yeah.
break, Sarah Boone. I don't have to inform you of every single thing that I do because that is too much information. It is an extra
Yes.
workload
Now,
that I don't need to do.
I will say, on a total off topic, Jedi Jess has sent me the transcript for the grand jury that they just released. I am big hot mad about this. I cannot believe the behavior of the prosecutors. So I will be doing a Mo loses it stream probably tomorrow afternoon because this needs to get out. How these people behaved was just beyond the I'm big hot mad and I'm gonna go full honey badger.
Send me an invite. I'll come by for that.
Okay. Yeah, I did an article about it, and Shizzy, I was about ready to load my Ford Transit with a bunch of like-minded people and go find these people and read them the riot act.
You need to maybe, make sure that your Ford Transit has plenty of gas in it and snacks because we don't want to ride along if we ain't got no grapes.
Oh, I'm a mom of 6. You know my purse contains all the crumbs of the universe plus snacks.
I know. That's why I was saying it.
My favorite thing is that she's not allowed a highlighter, so she stars the ones that are important to her case.
Yes.
What?
B. Prosecutor's discovery obligation. Within 15 days after service of the notice of discovery, the prosecutor shall serve a written discovery exhibit which shall disclose to the defendant and permit the defendant to inspect, copy, test, and photograph the following information and material within the state's possession or control.
A list of all the names and addresses of all persons known to the prosecutor to have information that may be relevant to any offense charged or any defense herethereto, or any similar fact evidence to be presented at trial under Section 94.404 2 Florida statutes.
B. The statement of any person whose name is furnished in compliance with the preceding subdivision. The term statement, as used herein, includes written statement made by the person and signed or otherwise adopted or approved by the person, and also includes any statement of any kind or manner made by the person and written or recorded or summarized in any writing or recording. The term statement is specifically intended to include all police and investigative reports of any kind prepared for or in connection with the case, but shall not include the notes from which those reports are complied.
E. Any written or recorded statements and the substance of any oral statements by co-defendants. E. Those portions of recorded grand jury minutes that contain testimony of the defendant. Every time I hear the defendant, I just want to go full Daryl Brooks. Like, we want to run the record back.
Oh,
She didn't have to say defendant like that. I was like, yes, she did. You're a tool. Go away.
oh. Any tangible papers or objects that were obtained or belong to the defendant. 6. Whether the state has any material or information that has been provided by a confidential informant.
Star, which means about me, Sarah Boone. H, whether there has been any electronic surveillance, including wiretapping of the premises of the defendant or conversations to which the defendant was party, and documents relating hitherto.
J. Reports or statements of experts made in connection with a particular case, including result of physical or mental examinations and of scientific test experiments or comparisons.
Oh, sorry. I was trying to multitask.
That's fine. Defend that.
Any tangible papers or objects that the prosecuting attorney intends to use in the hearing. This heifer just wants her cell phone back.
Yeah.
Or trial that were not obtained from or that did not belong to the defendant.
L. Any tangible papers, objects, you know, those little objects, the special ones, or substances, you know, little substances or anything like that in the possession of law enforcement that could be tested for DNA. You know what I mean, baby? What do you think I've been doing with those objects that you would need my DNA off of?
Whether the state has any material or information that has been provided by an informant witness.
If the court determines in camera that any police investigation report contains irrelevant, sensitive information interrelated with the other crimes or criminal activities, and the disclosure of the contents of the police report may seriously impair law enforcement or jeopardize the investigation of those other crimes or authorities, the court may prohibit or partially restrict the disclosure.
The court may prohibit the state from introducing into evidence any of the foregoing material not disclosed, as to secure and maintain fairness in the just determination of the cause.
What's the cause? Well, as soon as practicable after the filing of the charged documents, prosecutor shall disclose to the defendant any material information within the state's possession or control that tender to negate the guilt of the defendant to any offensive charged on any offense charged, regardless of whether the defendant has incurred a reciprocal discovery obligations. This is the important part right here. The Maurice.
Defendant's obligation. Well, as I am innocent, I am not a defendant. Score 1 for Boone, Lawyer of the Year. If the defendant elects to participate in discovery, either through filing the appropriate notice or by participating in any discovery process, including the taking of discovery deposition, the following disclosures shall be made.
A. Within 15 days after receipt by the defendant of the discovery exhibit furnished by the prosecutor pursuant to subdelusional B1A of this rule, the defendant shall furnish the prosecution a written list of the names and the addresses of all witnesses when the defendant expects to call as witnesses at the trial or hearing, when the prosecutor subpoenas a witness, or whenever whom has been furnished by the defendant, except for trial subpoenas, and the rules applicable to the taking of depositions shall apply.
Let's see. Within 15 days after receipt of prosecutor's discovery exhibit, the defendant shall serve a written discovery exhibit, which shall disclose to and permit the prosecutor to inspect, copy, test, and photograph the following information and material that is in the defendant's possession or control.
Ooh. Statement of any person listed in subdivision D1A other than that of the defendant.
Reports or statements of experts that defendant intends. I have a turtle ranch. Now, it is a place, it is great, but I am being attacked. Please donate to my turtle ranch. My anxiety is up to here. Intends to use as a witness or at trial or hearing made in connection with the particular case, including results of physical or mental examinations. To the poor SOB that has to interrogate this woman as a psychiatrist, we salute you. Or comparisons and triple I any tangible papers, objects that the defendant intends to use in the hearing or trial.
Ooh, number 2. Prosecutor and defendant shall perform their obligations under this rule in a manner mutually agreeable as ordered by the court. The filing of a motion or protective order by a prosecutor will automatically stay the times provided for in this subdivision. If a protective order is granted, I want to be protected, the defendant may within 2 days thereafter or at any time before the prosecutor furnishes the information or material that is subject of the motion for protective order, withdraw the defendant's notion of discovery and be required to furnish reciprocal discovery. Yeah.
Oh my gosh, this is going to be such a poo show. She's just going to write her own exam. She is going to examinate herself for mental acuity and give a report on her own mental health as an expert in Serenus.
No, she will probably get the she will probably use Torres as a witness.
You can't. He's passed away. How in the hell is he going to be a witness?
Well, his confessions from the suitcase.
Oh my God. She cheated. I cheated. Well, therefore, ipso facto, suitcasing
I was
in
defending
order.
myself. He was abusive to me.
Yeah. Oh my God. What is wrong? E, this is starred, which means that it is important to me, Sarah A. Boone, high school honor roller. Restricting disclosure. The court on its own initiative or motion of counsel, shall deny or partially restrict disclosures authorized by this rule if it finds there is a substantial risk to any person of physical harm, intimidation, bribery, economic reprisals, or unnecessary annoyance or embarrassment resulting from the disclosure that outweighs any usefulness of the disclosure. Ma'am, you are not going to be able to throw out your daggone phone because it embarrasses you. I don't know what you are thinking here. Everyone already thinks you're a schmuck, but honest to God, I mean, you can't embarrass yourself any more than you did in your interview.
Yeah. Yeah, they're going to throw that out because it embarrasses me. Additional discovery on showing of materiality. The court may require such other discovery to the parties as justice may require. Ooh, you get the sanctions.
Oh, all the sanctions. Star sanctions. If at any time during the course of the proceedings it is brought to the attention of the court that a party has failed to comply with an applicable discovery rule, the court may order the party to comply with discovery or inspection of materials not previously disclosed or produced, grant a continuance, grant a mistrial, prohibit the party from calling a witness not disclosed, or introducing in evidence the material not disclosed, or enter such other order as it deems just under the circumstances.
Well, and it seems to me that this is a fruitless thing because that's not what's going to happen. I mean, it seems like her thought process is, in preparing for trial, I've got to quote you all the statutes of how a court is supposed to operate.
Well,
And
that does seem to be what she generally thinks about the whole thing.
and that's what it appears to me, that she's just reciting all of this, that rewriting it from a law book, like all of the stuff,
Yeah.
and not taking it out of context, writing it word for word. Is just like, they might have something that you could like scan it with the picture of the law book you're using, because I'm sure that it hasn't changed much. And willfully violation by counsel or a party not as represented by a counsel of an applicable discovery rule or an orders issued pursuant thereto shall subject counsel or the unrepresented party to appropriate sanctions by the court. The sanctions may include, but are not limited to, contempt proceedings against the attorney or underrepresented party, as well as the assessment of costs incurred by the opposing party when appropriate.
Every request for discovery or response or objection, including a notice of deposition made by a party represented by an attorney, must be signed by at least one attorney of record as defined by Florida Rule of General Practice and Judicial Administration 2.505, in the attorney's individual name, whose address must be stated. A party who is not represented by an attorney must sign the request, response, or objection and list his or her address. The signature of the attorney constitutes a certification that the document complies with Florida Rule of General Practice and Judicial Administration 2.515. The signature of the attorney or party constitutes a certification that the signer has read the request, response, or objection, and that to the best of the signer's knowledge, the information or belief formed after reasonable inquiry, it is consistent with these rules and warranted by existing law or a good faith argument for an extension, modification, or reversal of existing law.
B, the important one, not interposed for any improper use or purpose, such as to harass or to cause unnecessary delay or needlessly increase in cost of litigation, as she's been doing. And C,
not unreasonable or unduly burdensome or expensive given the needs, if the case, and the importance of the issues that she may want to pay attention. The importance of the issues are at stake in the litigation.
You would
Because
think she'd want to do that, but
I would
no.
think murder is probably very much more important, and it constitutes a little bit different rules on this. Then there, of course, is the pre-trial.
Yeah. Oh my gosh, this woman.
Mm.
Oh, pre-trial conference. 1. The trial court may hold one or more pretrial conferences to consider such matters as who in the hell will represent this woman and why can't we just take her outside, as will promote a fair and expeditious trial. The defendant must be present at any pretrial conference unless the defendant's presence is waived in writing or on the record by the defendant or by the defendant's counsel with defendant's consent.
The court may set, and upon the request of any party, must set a discovery schedule, including a discovery cutoff date at a pre-trial conference. Mhm. This is you.
Oh, quote, that the individual shall have full protection in person and property is a principle as old as common law, but it has been found necessary from time to time to define anew the exact nature, excellence of such protections. Political, social, and economic changes entail the recognition of new rights, and the common law in its eternal youth grows to meet the demands of society. Now, this is going to be very funny. I want you to keep this paragraph in mind because at the end of this, I'm going to balls out laugh because she quotes from "We'll get there. It'll be hilarious."
Thus, in the very early times, law gave remedy only for physical interference with life and property. For trespasses via armies, I guess that's what it says, then the right to use served only to protect the subject from battery in its various forms. Liberty meant freedom from restraint and the right to property secured to the individual in lands and his cattle. Later there came a recognition of man's spiritual nature, of his feelings, and of his intellect. Gradually, the scope of those legal rights broadened, and now the right to life comes to mean the right to enjoy life, the right to let alone. The right to liberty secures the expertise of expensive privileges, and the term property has grown to compromise every form of possession, intangible and tangible. Bouvier Law Dictionary 2012 edition.
Okay, so she just hand wrote an entire diatribe on how one must keep abreast of new laws. Heifer is over here from the 2012 edition in 2024. I can't imagine that any laws or, zeitgeist of legal thought have changed in 12 years.
No, not at all.
Just
Oh my
excellent.
God.
Her ability to comprehend is awesome.
I know. It's going to be so great watching this. Oh,
What in the Mel Gibson Patriot are we doing here? American Declaration of Independence, 1776.
we have got to get like we just need to have a big bag of popcorn for this trial. Like I want to fill my room up with popcorn, and just so I can sit here and eat it from all angles and not fit through the door to get out
in
because
the
of this.
absolute poop show is she trying to do here? I mean,
Hey, Fast Group, how's it going? Good to see you. Mo in the deep end. Do you think she should write something to Auntie Bev?
You know, I think Auntie Bev's going to be a little white clawed out for the next couple weeks.
Oh my
So
God.
I'm not sure.
Wow, I thought Lynette could write a ton of stuff, but Sarah Boone should be sponsored by Bic.
In many ways.
Oh, God. Yeah, I mean,
Oh
Bic
my
and Chevron, one of those.
Pretty much. We hold these truths to be self evident that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness.
And not
Sarah,
being
it's the
stuffed into a
pursuit.
suitcase to suffocate.
Yeah, it didn't mean per suitcase. That's not what
Yeah,
that meant.
yeah, not per
To
suitcase.
secure those rights, governments are instituted among men, deriving their just powers from the consent of the governed.
Oh,
I feel very Schoolhouse Rock right now.
don't you? Well, we got the Florida Constitution. We, the people of the state of Florida, being grateful to Almighty God for our constitutional liberty in order to secure its benefits, perfect our government, ensure domestic tranquility, maintain public order, and guarantee equal civil and political rights to all. Do ordain and establish this here Constitution. Okay?
It just, what in the hell are we? Star clients, a person who relies on on the professional services of another. The client of an attorney is the person or entity represented and advised by the attorney. A client relationship commences for an attorney with an agreement, a big bag of cash, with performance of service in reliance on a request for representation or with a statement of representation on which the client relies. All attorneys owe a client a duty of zealous representation, balanced by the obligation to serve justice and act as an officer of the court. That's where your hiccup comes in, Sarah.
Yes. Attorneys also have an obligation to keep the confidence of the client at all times and to keep the client informed of all matters related to the client's interests. To inform the client of law, we relocated to the client's affairs and defer to the client's decisions, although the attorney has no obligation to the client to perform or refrain from any act contrary to the highest standards of professional responsibility and to the law.
Oh my gosh, this woman is ridiculous. Star, because this includes me, Sarah Boone, attorney client privilege. One of the oldest recognized privileges for honest, equitable, confidential communications intended to encourage open, full, and frank communication between attorneys and their client, thereby promoting broader, confident correspondence and in accordance to the appropriate observance of law and the administration of justice.
The only thing that she fails to understand is the attorney client privilege only goes so far. Now, whenever you start talking trash about your attorney or you go after your attorney verbally, you start waiving that attorney client privilege because they have to defend themselves. So, in carrying on and being a little poopy butt, what happens is whenever you start talking trash about these attorneys and start going off on them, they have to explain to the judge why exactly that they are no longer wanting to represent you or unable to represent you. And most of the time they're going to try to do it in a very kind way so the judge understands. They're going to use nice words to say there's just irreconcilable differences. Not that this lady is batshit freaking crazy, because that doesn't go well with a judge. The judge is going, okay, I got it. We will handle her with kid gloves. And this goes for just about everything that this psycho is doing, because
Yeah.
zealous advocacy. An attorney must represent each client to the fullest extent. And this is the key part that you're failing to recognize under the law.
Yeah,
And
that is the part where she's confused.
Requires representation to the attorney's fullest abilities without violating the rules of professional responsibility. These are the key words that she's failing to recognize. They're not getting through to her head. It requires not only presenting each argument required by a client to every institution in which that client has business, but also framing each argument in the strongest terms of law that greatly benefits the client while remaining faithful to the facts and the law itself. This is something she should have paid attention to. The fluffy white gluten-free popcorn bowl size $46.99. Jesus, that's not going to be enough for this case. I'm just saying. On Amazon, I know. Oh my God, 288 cups of fluffy white gluten-free popcorn bowl. Oh, that would be so sick at the end of that. No, I'm talking about I gotta have it so I can just cover myself, and all you see is like a little shizzy head here. But this is probably the one, the most important thing that she's not getting through to her thick skull. That a jurist, which is an attorney, a jurist is very responsible for the conduct of themselves in a court of law. They have to apply the law to its fullest. They can't just sit there and go, well, we're not going to apply this law because that doesn't really matter. That includes they're contained under those laws, such as attorney-client privilege. Like if you tell your attorney that you were turned on by it while you were doing this, they can't disclose that. While you were committing this act, they can't disclose that. But if you tell your attorney, I absolutely stuffed him in there, zipped it up, kicked him a few times, I hit him with a baseball bat, threw him down some stairs, took a few pot shots at him, you're admitting to a freaking crime.
Yes, it's a crime. And zealous representation advocacy does not mean that they can break their code of ethics. They are considered an officer of the court. They are held to a much higher standard on their ethical requirements, so what she's not getting through her mind is, I mean, we've talked about this before. What she wants to be told is that unintentional means not guilty, get up out of prison. That's not going to happen because reckless homicide exists. Manslaughter is a thing. So it's there are none so blind as those who will willfully not see.
Oh, and here's the thing. It is no different than if you see someone drowning. If you don't attempt to go save them, which I understand, you might have a reason for saying, I can't swim, I am not going to risk my life to go out there for this person, but you call 911, they're not going to find you guilty of unintentional manslaughter. Big difference there. You're calling 911, you're like, I can't swim, I can't help this person, I'm letting people know that I'm seeing something happening. You're a witness to something happening. Big difference as compared to stuffing them in a freaking suitcase and then recording it while they can't breathe and laughing at them. There's a big difference.
And what she also doesn't understand is that video shows malicious intent. What she doesn't get is that, she can explain away all the thing while he was laughing and this, that, and the other. But this is, again, she wants to hear not guilty, and she's not going to. And oh my gosh, she's going to make the rest of us suffer as she continues to not understand this general concept.
Yes.
Zealous advocacy is a requirement of the oaths required by attorneys or admitted to the success of the adversarial system of justice. Disruptive, disrespectful, disregarding, or disparaging rhetoric is never an inclusion of zealous advocacy, and the use of such crosses the line from acceptable forceful advocacy into unethical conduct. Bouvier Law Library 2012 edition,
Oh,
staying currently abreast of all changes in law.
Oh my. Well, then, of course, we have the attorney misconduct. It is a failure of an attorney to comport with the rules and accepted professional customs of the bar, and includes any act or omission of duty by an attorney that fails to perform appropriately the office of an attorney as an officer to the court, as such a counselor and fiduciary of a client, or as a member of legal profession. The scope of attorney misconduct reaches also to the conduct of attorneys that is harmful to the appropriate reliance of the citizenry upon the law and legal profession.
Attorney misconduct includes actions or omissions that enable others to harm, not just harm caused directly by the attorney, and not all misconduct is subject to remedy or sanction, although a variety of forms of each exist.
Well, the misconduct may always be the basis for a client to remove an attorney from their duty of representation, as if any other cause for the client's loss of trust and confidence in a lawyer. And
And,
go ahead.
oh, go ahead.
No, do it.
And the attorney's demeanor to determine whether a party's substantial rights were affected. Based on repeated or persistent objected to misconduct, the district court shall factor into its analysis that motion
Notion.
is that the
That's
notion that the notion by engaging in continued misconduct, the offending attorney has accepted the risk that the client's case may be influenced by said misconduct. Therefore, the district court shall give great weight to the fact that a single instance of improper conduct that could have been cured by an objection and admonishment might not be curable when that improper conduct is repeated or consistent. Again, Bouvier Law Dictionary 2012 edition.
But we have duress. It's an unlawful threat that limits the person's independence of judgment or action. Is any improper threat or condition, such as a coercion, that limits a person's ability to think or act independently, and the presence of these destroys the independence required of the party subject to.
In order to constitute a voluntary consent, it must clearly appear that the search was voluntarily permitted or expressly invited and agreed to by the person whose right it is involved. In addition, such person must be cognizant of their rights in the premises. The consent must not be contaminated by any duress or coercion, and the government has the burden of proof. This heifer wants to say that because they told her she was coming in for an interview and not an interrogation, that they
Oh,
coerced and bamboozled and shenaniganized her, and
well,
she was under duress. It was coercive, and therefore none can be used against her. She is so
but
dumb, it's not.
but the only problem is she expressly invited and agreed to in person whose rights are involved, which means that she waived her rights.
Well,
And
she
that
did give
brings
her
part
Miranda rights. And
yes. Well, this brings about that there habeas corpus. Now that there's a review of the lawfulness of a person's custody or that they're restrained by a government official, it is one of them their processes of judicial review of any person's detention, whether by normal custody or incarceration or continuing restraint by an official or an agent of the government or state or federal government. Is she gonna go? Is she gonna go south set on us? I would love it.
I hope so.
Let me get
Let's
this
get her a
next one
pamphlet.
too.
Let's sure, I'll get the 2-starred.
Oh yeah. The right of review of a custody by habeas corpus is a fundamental constitutional right. It is a bulwark of the individual liberty being used to free the peoples by the courts without the legal authorities or without having complied with the requirements of the law. Habeas corpus is protected in the U.S. Constitution from their interferences.
Star, a defendant who has been confined for 30 days after their arrest without a trial shall be allowed a preliminary hearing upon application. Number star, informal consent, consent given with appropriate knowledge after the person giving consent has learned of all the information that would be reasonably required for a basis of reasonable decision. In many instances, for institutional or professional, to prove that a decision maker was sufficiently informed over a matter to give informed consent, the institution of or professional will provide the information in an informed way, but the provision of this information is not a legal requirement to receive informed consent unless a custom statute or regulation requires it.
Well, now, let me just say this. An attorney or other proposal professional, they have an obligation to provide any person with adequate information and explanation of a proposed course of action and its alternatives for the person to know of the material risks of each before constituting consenting. By definition, professionals and the fiduciaries have similar obligations to their clients and to these with a reasonable right to rely on their information or advice before consenting.
The lawyer or other professional shall, 1, promptly inform the client of any decision or circumstance with respect to which the client's informed consent, as defined in Rule 1.0, subsection E, is required by these rules. 2, reasonably consult with the client about means by which the client's objectives are to be accomplished. 3, keep the client informed about status of that matter. 4, promptly comply with reasonable requests for information. This woman is nuts.
And you got more.
Oh, sorry. Consult with the client about any relevant limitation on the lawyer's or other professionals' conduct when they know that the client expects assistance not permitted by the rules of professional conduct or other law.
Well, now, we also have in there legal ethics, professional obligations of lawyer, including those codified by rule and body of rules and standard of conduct that the legal culture imposes on its members. Ethical standards arise, as does their authority over the attorney. From the oath of the attorney, the inherent power of the courts to discipline a lawyer before the bench, the culture of the proposition, and the standards of liability for fiduciaries and professionals under these rules. Legal ethics usually require attorneys to avoid conflicts of interest, to practice with diligence, to avoid frivolous, false, fraudulent, or harassing behavior, to zealously represent clients, and generally to avoid the appearance of impropriety. A violation of legal ethics subjects the professional to sanctions from the professional bar and courts.
Booyah Law Dictionary 2012 edition.
Star for me, Sarah Boone. Equal protection of the law Each should treat similarly situated individuals in a similar manner. Equal protection of the law is one manifestation of the ancient principle of equal justice under the law and is required in the U.S. Constitution by states under the 14th Amendment's Equal Protection Clause and by the national government under the 5th Amendment's Due Process Law Clause. Equal protection requires each law, whether it is a statute, regulation, order, or application of customs, to treat similarly situated people similarly. Interesting.
Oh yeah, don't worry. I'm about to break out a little bit of Volstorm feelings here. Let me see. The abuse of the process. It is a claim. Now, it's not just a claim, but it's a claim for the harm of misuse of a legislative legal process. Now, this is a claim that can be brought when a pleading or procedure is wrongfully employed for the purpose of harassing or injuring the opposing litigant. Did I say that right? Litigant. Examples including filing a false affidavit. My arrest affidavit has someone else informed is used, and also no for the domestic violence when sworn to be true and correct by Connolly, co-pestle, impeachment document. Now that they're the detective in my case with other discrepancies have been made in my case. Yes, they've been made in my case, making false claims. See the interrogation videos, introducing fraudulent evidence, statements, assumptions, and the guesses.
Pleading true international pressure, abuse of the process requires moving. What the hell is she writing? What is this handwriting?
It is
Through,
so bad.
to prove the three elements. That I used to be a lawyer. I was a lawyer and a senator. That the legal process had been initiated properly with the thing. You know the thing, Joe. Come on. The process was substantially, really.
Subsequently.
There's not a kid around.
Subsequently.
Perverted. I am not perverted. That is a lie. That is a deep fake news. And you have the morals of an alley cat. The process was not originally designed. I redesigned all the processes. Original perversion caused harm. I, only showered with my daughter a couple times. Abuse of power of process involves the misuse of the Constitution. Everyone, in closing, America is a country that can be summed up by one word, and that is line.
Democracy. The essential elements of abuse of process are ulterior purposes and willful act in the use of process not proper in regular conduct of proceedings.
Oh my God, this is such a ridiculous, redemptive thing. Star interrogation, examination of a suspect. The process of inquiry by which the police or other law enforcement personnel, but no longer John Proctor, seek information from a person suspected of a crime. Another star interrogation is distinct from an interview as titled on my transcripts, in that the police seek not merely information in general from the suspect, but also statements from the suspect that are either directly or indirectly incriminating. This may involve direct questioning or other action designed ultimately to elicit a an incrimination and is subject to due process of law without any compulsion of any kind.
Let me tell you, dear little darling, interrogation, as conceptualized in the Miranda sense, reflects a measure of compulsion above and beyond that inherent in custody itself, referring not only to express questioning, but also to any words or action on the part of the police other than the normally attended to arrest and custody that the police should know are reasonably likely to elicit incriminating response from that there subject.
Star, because it's important to her, custodial interrogation. Interrogation of a person in the custody of law enforcement officials is following a person's arrest or custody. The hallmark of a custodial investigation is that the person knows that the person is in custody and has no freedom to leave. I didn't know I was in custody and I couldn't leave. I was told by Kibisku Kapelsic. Is that
Keep
a U
cell.
or an L?
Keep cell,
Kipsel,
maybe. Keep cell.
to come and pick up my phone. He no warning of being interrogated again. Being a custodial interrogation, the stakes of interrogation are higher than if a person is free to go. Any statement made in custody during is presumed to be coerced under the Fifth Amendment. No,
Presumed
I'm
to
pretty
be
sure.
no.
No, I'm pretty sure that they interrogate folks in the clink all the time. Otherwise, I'm pretty sure most people wouldn't be in jail.
Go ahead and finish this part out there, the constitutional.
The Constitution distillate of Miranda is that self-incrimination flowing from custodial interviews is ipso facto compelled self-incrimination because of the inherent coercion, inherent compulsion of the custodial interrogation environment.
Well, now, here's where we get to that there excited utterance, spontaneous declaration, or spontaneous exclamation. This does not apply to it because spontaneous declaration would be like, oh, he done died. That's not what it is. An unthinking statement made at a moment of great surprise. I'm surprised that you are an idiot. At the moment of great surprise and stress.
I was stressed. I was so stressed I couldn't stress it enough.
An excited utterance is a statement made during immediately after the declarant is surprised by a starting or event condition.
I was so surprised whenever you opened up my phone and you showed me just kicking him in a few times and rolling around in a suitcase and poking fun at him. You're done. You're not going to see how does it feel?
That would be an excited declaration for me.
This is where it gets even more funny.
Is surprising by starting an event or condition with declarations is under the stress of an excitement caused by the event or the condition. And this here is the United States, North Carolina. Oh, look, we have the publicly exploitation and saturation. Okay. We're drawing maps. Okay.
She's starring where she's gotten fan mail from or hate mail.
Oh, is that what it is?
Yeah, so she's starring all the states where she's received letters or communiques.
Oh,
She's
that's what
trying
she's
to
doing.
explain that she's not gonna. And I swear to y'all, I am not the Indiana one. I mean, I have been tempted a time or two, but I'm
But-
actually just lazy, so I haven't wrote her yet.
Oh my gosh. Well, look, it's North America. And then she zooms out, man. We got people over here in this little country. I don't know what that is. I think is that Denmark? Damn. Baker, I told you. And then someone off the coast of North Africa, I think. Maybe I can't really read the map.
In Singapore.
Publicly exploitation and saturation, United States map, page 1.
To date, each star is a state where I have received correspondence via mail or message regarding my current criminal case. World map, page 2. To date, each star is a continent where I have received correspondence via mail or message regarding my criminal case. The number grows daily. Most all letters and messages are available for review and understanding of the impact of my case details being made readily available on the global internet, creating wrongful ignorance, hate, and massive prejudgment before my trial. I, the defendant in my case, have not yet, ongoing 5 years, fully reviewed or even seen all of my case details. Everyone in the world has already had the opportunity to do so themselves. Ma'am, it's called the Sunshine Laws. I'm sorry that they worked against you. Maybe you should have, done your drive-by suitcasing in California.
Well, the continuation of this obvious exploitation allows the world to keep pressing their incorrect, presumed unfair theories, ideas, accusations, forcibly insinuating I committed criminal acts. You did not see the videos from my perspective. My present attorney said it is not necessary to receive a court order. I've been trying to obtain to download my case information to apply from the OCCD tablets. My former attorneys are withholding some of my case contents I have supplied to them and which have been deemed lost. Many other items have been returned, not to myself, but to the next attorney, and which have been unable to be located to date. I'm missing innumerable case items which I continuously request to be returned or obtained without success.
Invasion of privacy, Supreme Court, wrongful conduct. 1. Appropriation. The unlawful use of a person's name or likeness to obtain some benefit. Sweetie, no one wants to take your identity. I only play you badly on YouTube. 2.
Yeah.
Intrusion, physically or electronically intruding into one's private quarters.
Doesn't
3.
apply here.
Public disclosure of private facts, the dissemination of untruthful private information which a reliable person would find objectionable. Again, you're accused of a crime.
Yes.
These are public records. What do you fail to understand?
Yeah, continue on. Finish out the page.
False light in the public eye, publication of facts which place a person in a false light, even though the facts themselves may not be defamatory. Star, defame, to injure or destroy the reputation of by libel or slander. Anything is defamatory if it, quote, has the tendency to render the party about whom it is published contemptible or ridiculous in public estimation. Sarah, you took the video. You did the interrogation. You exposed yourself as ridiculous and contemptible, or expose them to public hatred or contempt, or hinder virtuous men from associating with him. Ma'am, you're not going to be around a virtuous man for a long time, okay? An opinion can be actionable if it implies the allegation of undisclosed defamatory facts as the basis for the opinion.
Well, let me tell you there, sweetheart, the invasion of privacy, false light, publicized in some matters to create a false and harmful impression. False light is both a theory of invasion of privacy and in some jurisdiction an independent cause of action. Don't you know this? Arising when a person, one, gives publicity to a matter concerning another person that places the victim before the public in a false light. Well, that didn't happen here because let's see. You videotaped you laughing while you had someone in a suitcase when they begged to be let out. That would be highly offensive to a reasonable person. Nothing you did was reasonable. And a reasonable person would find it offensive, everything that you did. 3, when the person giving or creating the publicity either had knowledge of the false light, but it has to be false, that would be result in acted reckless disregard of the falsity of the publicized matter or the false light in which the other would be placed. Now, let me give you a perfect example. That would be like Mo saying that I did something horrible and awful, and then continuing that narrative, saying that Shizzy did something horrible and awful, and perpetuating this lie
Yeah.
and putting me in a false light. That's what that means, sweetheart.
Yeah.
Mo isn't doing anything to you that you haven't done to yourself already.
Yeah.
She's just placing the facts out there of what you've shown her.
Yeah. To be fair, if you'd like to have an exclusive interview, Sarah Boone, I know you're watching all of these. Okay, I'm going to be honest. I'm probably going to make fun of you, but I'll use big words to do it so you'll feel intellectually stimulated.
I'll use small words so you'll feel intellectually smart.
Nope, I'm going to use big words, but I'm going to say them slightly wrong and then tell her I'm a court. So I'm going to be like, no, it's objecture and sustain. It's not sustain. No. And it's tacket.
Hack it. Like me putting little things on the wall, hacking it.
Oh my God, what a dingus.
The line is drawn. Yeah, I'm sorry.
Oh,
Because
wait.
I already read all that.
Oh yeah, public. So I'm on public exploitation and saturate. Oh, for the love of all those godly.
Oh. You get them underlined.
Public
too.
exploitation and saturation. My personal, individual, criminal case is being advantageously exploited and abused. From all of my significant life-saving suppressible case details, evidence, proof of being illegally obtained by my coercion, trickery, duress, confusion. Sweetie, that's the Department of Education's fault. And without my permission, in any form, written or verbal, to anyone, then broadcasted, distributed, hand delivered to the entire planet, states, countries, continents, containing all my potential, or contaminating all my potential jurors, causing irreparable, erroneous, falseness, greatly tainting my jury pool. Ma'am, you already taint the humanities gene pool.
She is a taint. I'm sorry.
By forcefully attributing heavily influenced, incorrect, inappropriate motives, theories, ideas.
Okay. Well,
obvious.
Yeah, go ahead.
Privacy is creating unnecessary, unlawful oppression, depleting all of my entitled opportunities to be given a fair, proper, successful conclusion of my case. As a prejudgment has already been made unfairly against me. This is the worst kind of discrimination, the kind that affects me, Sarah Boone. Violations of my constitutional rights and due process law as a result of my entire case and personal life being publicized globally before my rightful trial, which lawfully, ethically, I should be without disadvantage. And well, ma'am, you're still part of it. That's called a handicap. And free from all participatory partiality, deceitfulness, and dishonesty made from said evident exploitation.
Well, definitions collected from the Bouvier Law Library, Merriam-Webster Dictionary, and Smart Communications Tablet. Exploit, unfair, irrational use, the taking of an unfair or unreasonable advantage of a person, thing, resource, or circumstance. exploitation. Now that there means an unjust or improper use of the resources of vulnerable adult for the profit and or advantage, monetary or otherwise, of a person other than the vulnerable adult themselves. The use of undue influence, coercion, harassment, deception, false representation, or false pretense. And then, of course, we have the abuse. It is a corrupt practice to put the wrong use, to misapply, misuse, pervert, or application to, and for the wrong purpose. And then, of course, we have significance. It's deserving to be considered important, monotonous, or having meaning likely to be consideration or influence or effect. Suppress the restriction of a person's action or speech to keep from being known, to stop the publication or circulation, to hold back.
Number 5, illegal, not lawful or sanctioned by official rules, not according to or authorized by the law, illicit. 6, to coerce, to restrain, especially by law or authority, to repress, to compel or constrain to any action as to coerce someone to vote for a certain candidate. Generally, dictionaries don't use the word to define the word. 7, trickery, deception by trick and stratagems, fraud. 8, duress, how this case is going to make me feel. The state of compulsion or necessity in which a person is influenced, hardship, pressure, constraint. 9, confusion. Yep, there too. To make mentally unclear or uncertain, to disturb the composure of, the state of being mixed or blended. I like my margaritas blended. To
Yes.
produce indistinctness or error, or to cause or make disorder, tumult. 10, broadcast, scattering in all directions to spread widely, to make widely known, or over a wide area. The transmission of sound or image by radio or television, cast or dispersed in every direction. 10, to distribute, to divide among several or many, to deal out, appropriate, a portion, a lot, or to spread out.
Well, now we got that there. It's called deliver. So it's what you do whenever you drink too much alcohol, or to send an intended target or destination, convoy, transport, or release, to give a yield or possessionable or control of, like I like being controlled, to make over the knowledge of another, give forth an action or exercise. Irrepayable. It's impossible to make good because you can't irrepay them. You can't undo her. You can't repair it. You can't remedy it. It's not repairable, not capable of being fixed, or because it's done broke. And then we've got ear on her. Well, it's incorrect. It's wandering or straying like a dog in heat, deviating like a little cockroach when a little son bitch runs under the counter, and you deviate him just a little bit with a baseball bat, might deviate someone's septum too. It's misleading or mistaken, and then we've got we got falseness or fairness or falseness. It ain't one of them genuine things. It's artificial, like it's like Stormy Daniels' boobs, artificial, intentionally untrue, just like Trump, adjusted or made so to deceive, just like Biden, tending to mislead, inaccurate, based on mistaken ideas, just like Hunter Biden, and contrary to the fact, just like Kamala Harris, double dealing and petrified, just like Biden. Taint, just like me. Taint what I said, taint what I mean, because it taint corrupt, it taint contaminated. Well, my taint might be contaminated just because I wipe forward, not backward, to affect or become affected with something bad because I wipe forward, not backward, contaminating mark, just like stretch marks, or what do you call them brown streaks in my drawers? Contaminated my taint, influence or imbued with something extraneous, just like my taint is, especially with something poisonous, just like my taint is. Force. That's the strength that you need to remove that taint. Energy, exceptional degree. You get down there with the scraper, and if you need it, you get yourself a hammer and a chisel to knock out the dangleberries. Active power capacity to persuade or convince. Now, it would just been better if I would have got one of them little squirt bottles, that you hook up to your toilet. I think they call it what do they call that thing? It's a water fountain that just sprays up in your little tank. Well, an influence that causes a notion or change of the motion. Now another thing that can do that, if the motion of the ocean don't fit, well, you don't stuff them into a suitcase.
Influence. From CNN, your trusted name in news. The act or power of producing an effect without apparent force or direct authority. The power or capacity of causing an effect in direct or intangible ways to condition or development of or by a gradual process, controlling power quietly exerted. We don't do that here at MSNBC. I'm Rachel Maddow.
Well,
Incorrect. Not correct. Thanks for spelling it out, Merriam-Webster. Not according to established rules. Inaccurate. Fault. Not in accordance to a copy or model or testimony. Not true. Wrong. Inappropriate. Sarah Boone, fitted to a wrong purpose or use. 21. Motive, something as a need or desire that causes a person to act, that which produces conception, invention, or creation. I didn't know that there had to be motives behind conception, but okay.
I mean, I don't know, man.
It's usually intoxication, not motivation.
Well, it wasn't really motivation, but I was intoxicated a little bit.
In the mind, or a guiding or controlling idea of or relating to motion.
Motion.
Invade.
Just like my mind is.
Warlike or hostile entrance into rights, possessions, or domain of another, trespass to enter for conquest or plunder, or maybe likely suitcase.
We shall rape the horses and steal the women's.
Pretty much. Privacy, a quality or state of being apart from others. Secrecy, a place of seclusion from company or observation. Look, everyone wants privacy from you, Sarah.
Yes, because we have the oppression. As we know, the oppression, that's the hardship, injustice, impose, exercise, breeders upon, to overload, to treat with the unjust rigor, of cruelty, to crush, by abuse of power or authority, to weigh down, to persecute, to wrong, deplete, just like my brain has been depleted, to reduce, by destroying or consuming the vital powers of the exhaustion or strength of resources, to empty, to void it out. To destroy is to deplete it. Entitled, just like me, entitled Russian man, give right or claim, qualify for furnished with grounds for evening or claiming with success to attribute or ascribe. Fire, 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 we're very far here, conferring with the rules, free from obstacles or hindrance, obstruction, character, or dies by honesty, impartiality, without any suspicion, bias, or marked characteristics. I'm going to fly my flag. I'm going to fly it high because I'm proper, marked by a suitability or rightness in all aspects, appropriate and excellent.
Successful, resulting in success, accomplishing what was proposed, favorable, or desired outcome, the result of an undertaking, endeavor, or an effort. I'm full of effort.
Oh, for the love of God. Prejudgment. To
Is that
judge before hearing or full and sufficient examination.
You mean
To
that's not the
decide-
mint they leave on your pillow at the what do they call it, the Motel 6? That mint on the pillow isn't a prejudgment.
Sweetie, that's a hour by hour hotel. If you find anything on the pillows, don't touch.
You're not supposed to touch the brown stuff on the pillow?
No.
Baby.
To condemn beforehand. Unfair, marked by injustice, partiality, deception, unjust, not fair or honest, disingenuous, using or involving trick or artifice, unequal, undeniable, plainly true, incontestable, unquestionable, not deniable, indisputable, violate, break, disregard, interrupt, or disturb, to obscure, infringe, non observance, the violation of law or positive command of covenants, promises, anything that should be held sacred and respected, and the contemptuous treatment of 34 constitutional rights. A right protected under the Constitution of the United States of America and the newest contemporary sense of right, which implies a greater emphasis on the idea that rights is conferred upon the person by the Constitution. No, it's conferred by God on the person. Well, I guess natural rights, negative rights. Okay. Without Constitution, the person would have no rights. Enforcement of constitutional rights is a matter not only for the court, all branches of governments also.
Oh, well, then we also have the liberty rights. It is the constitutionally protected ability to engage in certain conduct or hold a certain status, and in doing so, to be protected from interference by police or other agents of the government. Even whenever you stuff a man into a suitcase, zip it up, and let him pass away at night, unless that interference is well justified and legal, which I was totally justified. It was totally legal. I just stuffed it. He climbed in there on his own. We're playing hide and go seek. The right to privacy. He was being private. I was abiding by his right to privacy. He didn't want me disturbing him, so I just left him in there. He was in his safe space and freedom of speech. He said everything that he wanted to say to me while he was in there. I'll skip over this one. Let you do the next one.
Oh, privilege or positive right, sometimes called a claim right, the constitutionally protected ability to call upon agents of the government to assist in performing certain conduct or hold a certain status, and in doing so to be protected from interference by other government agents and by private parties.
No, we got the procedural right. Now, this procedural right,
This is the constitutional requirement enforceable by the citizen that the agents of the government act only in certain ways, according to certain rules, in consultation and agreement with another. The rights to laws made according to specified procedures, the trial by jury, and to be free from torture, except whenever I feel like, well, those are just some examples.
God. Fundamental to all these rights is a constitutional right in which individual that the agents of the government will abide by the Constitution and do nothing through the power of the state that is not allowed to them to do by the Constitution. The right is not be taxed for unlawful purpose, for example.
Well, now that brings us to the due process. Okay? Now, due process, constitutional rights in life. If you want it, liberty if you need it, and property interests that cannot be burdened without due cause or appropriate procedures. Now, due to process of laws from fundamental aspect of the law, because including not only the process by which that law must be created and applied, but also the scope within which certain laws must be made and enforced, and beyond which laws ought to leave individual to their own liberty. Don't be infringing on my liberties, because I'll take liberties with your wife and your dog, maybe your daughter too. Don't be infringing on mine. I will not be infringing upon yours.
The Due Process Clause of the 14th Amendment prohibits state governments from depriving any person of life, liberty, or property without due process of the law. Thus, due process includes both a procedural and substantive aspect.
Well, now let's dig into this a little deeper, darling. Procedural due process rights are meant to protect persons from mistaken or unjustified deprivation of life, liberty, or the property, and entitles a person to an impartial, disinterested tribunal in both civil and criminal cases, sweet cheeks. Protected two central concerns: the pre-definition of an unjustified or mistaken deprivation, and the promotion of participation in dialogue by an affected individual is the decision-making person, and I've made a decision. So what do you tell me the other one is there, sweet cheeks?
Substantive due process rights are those fundamental rights and liberties which are objectively deeply rooted in this nation's history and tradition. They are those rights implicit in the concept of ordered liberty. No man of what estate or condition shall be put out of land or tenement, nor taken, nor imprisoned, disinherited, put to death, without being brought in answer by due process of the law.
Well, now,
Analysis of either a procedural or substantive due process claim must begin with an examination of interest allegedly violated and possession of protected life, liberty, or something else, property interest, is a condition precedent to any due process claim.
yeah, but if we're gonna, publicize to bring publication attention to or advertise, then, we got to think about, number 37. Rightful. I'm rightful. I have the right or just claim according to established laws. Belonging, held or possessed by right, constant to justice. And as my friend Vinny would say, lawful, permitted, constituted, authorized by law, rightful, legitimate,
Competent.
ethical. Now, this is something you need to pay attention to because ethical is conforming to accepted and professional standards of conduct or of belonging to, no risk. Treating the moral feelings and duties according to harmony with the normal principles or character.
Disadvantage, an unfavorable, inferior, or prejudicial condition, quality, or circumstance, unequal position, especially to reputation or finances. 41. Oh my God, how many more definitions does vocab chick
Oh,
have?
yeah.
Partiality, inclined to favor one party in a cause or one side of a question more than the other. Biased, not indifferent, having a predilection for, inclined to favor unreasonably, special taste or liking. Deceitful, an
Deceitful.
attempt or disposition to lead into error, any trick, collusion, contrivance, false report, representation, or underhanded practice used to defraud another. Fraudulent, causes to believe what is false, entrap, seduce by artifice, mislead. Ma'am, no one wants to be seduced by any of your artifices, okay? Not one.
Oh my God.
Dishonesty, void of integrity, faithless, disposed to cheat or defraud, violation of trust or justice, untrustworthy, want of fairness, to betray, evident, clear to the vision and understanding, satisfactory to judgment, apparent.
Well, now, sweet cheeks, you have to remember that them there exciting utterance are admissible evidence despite both the hearsay rule and the confrontation clause, because they are only admissible when the circumstances of the statement are sufficient to demonstrate that the statement was an unthinking, unplanned reaction to events, such as saying that he's dead. Killed him.
Unintentional.
Saying
Why
that he's
is he
dead. I killed
purple?
him. Now, that could be considered an excited utterance, except for whenever you say that you stuffed him in a suitcase. That would not be an excited utterance. You saying that, oh my God, he's dead, I killed him, could be considered an excited utterance. And the
What is
way
she
that that works, if you
so
look at it
wrong?
in the same aspect of if, for example, I said something horrible to Mo, and at that same moment, Mo was struck by lightning. I said, Mo, you're a horrible, blah, 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 blah. And you were struck by lightning. I might go, oh my God, I just killed Mo. That would be an excited utterance. Not
Yeah.
that I did, but that would be an excited utterance.
Well, also don't state that in the Commonwealth of Massachusetts because you might get charged.
I'm giving Starzy a hard time there. Starzy said, evening all, happy Canada Day to all fellow Canadians, and happy 4th of July in advance to all our American friends. Thank you so much. What is it? What is it that Volstorm says? Now, this is funniest thing. He says there's snow Mexicans.
What? I have never heard this.
I hadn't either, but I was like, that is so awesome.
I mean, but they're French most. I mean, you have to learn how to speak Quebecois or something.
It's an American thing. It's the same reason why one of my friends, he thinks that everybody walks around carrying 6 shooters and we have shootouts on a daily basis at the OK Corral. He's in Canada. I'm like, that's not true, right? He was like, man, prove me wrong. He goes, the stories I've been hearing.
To be fair, some of the people in my neighborhood have decided to party hard, and well, all this last week and this week, party hard for patriotism by blowing, their lawns up, and I'd be kind of tempted at this point.
Yeah,
I have never understood spending like $400 on fireworks. You are literally going to explode them.
Yes.
Why? Also, your fingers. because nothing
Explosions.
mixes like an air.
This is awesome. The Massachusetts State Police trooper who read his vulgar text about calling her the "see you next Tuesday" about Karen Reed aloud in court has been removed from his position and will no longer work cases, officials announced. That's beautiful. As of July 7th, the date required by Troopers' collective bargaining agreement, Proctor will no longer be allowed to work cases or function as a pooper scooper. Proctor is still an employee of the department.
Yeah, but now is he their secretary or their receptionist?
Yeah.
Asking for a friend. Not that
Well,
there's anything wrong with being either. It's just kind of a demotion from trooper.
I mean, wasn't he always a receptionist? I mean, a receiver? Oh, I'm sorry. Was he a giver or he was a secretary?
Like he gives of himself at all. His wife is the most unsatisfied woman in America. Change my mind.
Yeah. This follows a previous decision to open internal affairs investigation after information about serious misconduct emerged in testimony at trial. This investigation is ongoing, Mon said. Beautiful
Oh
stars.
my gosh.
Our focus remains on delivering the highest level of police services with professionalism and integrity.
Okay, so Shizzy, if I were to make Trooper Proctor dress up like Hank Azaria from the Birdcage while handing out coffees, would that be considered harassment? Because that would be a possibility if I were in charge.
So funny. Be so harassing. I'd love it.
Okay, now you have to watch this movie 84 times, and if you don't speak in correct Hank Azaria, you will be fired.
Yes. Yes. By definition, a statement may be an excited utterance and not perfectly contemporaneous with the event, but it must be made while the emotional state caused by the event or conditions persists. Many, though not all statements not that are excited utterances are also forms of the statement or present sense impression. Oh my God, more of her freaking definitions.
Yes, there's 873. I think we are on like the last page, I think.
Yes,
maybe.
we are on the last page.
Coercion, unlawful force, fear or threats used to spur another to conduct. It is in the influence, compulsion, or restraint that diminishes free will and causes them to do or to refrain from anything. This is the basis for crime of criminal coercion, which is a form of blackmail.
Now there's also
Freedom of Information Act, FOIA, a federal or state statute requiring government agencies to release information on request. It is a statute that requires dissemination of information held by government agencies throughout regular publication of such information or by the release of such information only by request. The 9 categories of government information exempt from Freedom of Information Acts are 7. Law enforcement records, if their production could reasonably be expected to interfere with enforcement proceedings to deprive a person of a right to a fair trial or an impartial adjudication, to constitute an unwarranted invasion of personal privacy, to enter or endanger the life or physical safety of an individual.
Well, that's awesome, doll. You know why that's awesome? Because after she filed this, the order came across, this cause came before the court on June 28th, 2024, on defense counsel Patricia A. Cashman's Esquire motion to withdraw counsel filed June 11th, 2024. The motion, the court having reviewed the motion, having reviewed the court file, having reviewed the audio transcripts of various hearings, copious amounts of hearings, having considered the positions offered by counsel Patricia A. Cashman Esquire, having considered the testimony offered by defendant Sarah Boone, and having considered the positions offered by counsel for state, hereby finds On March 23rd, 2020, by way of information, the defendant was charged with murder, second degree of the murder. Procedural, we'll go through all the procedural at some other point in time because basically it just says that everybody said we cannot represent her for various reasons. Not all of them were her fault. Some of them because they were counsel to a witness or because they were counsel to the decedent. And the same irreconcilable differences arise between undersigned defendant may have been possible undersigned, same irreconcilable differences, blah, blah, blah. On May 10th, 2020, a hearing was held on Padilla's and more of the same that everybody said, no, we cannot handle with her. We will just move on to our next case because her case is she's completely batshit crazy. But where it gets really interesting is at line W, and then we move on to line X. X marks the spots because on December 27th, 2022, a hearing was held on Banquet's motion to withdraw. Defendant was present for this hearing and was sworn. We swear she's crazy. The court advised the client, the defendant, the court had received letters from the defendant filed on October 7th, a letter dated and another letter dated and another letter dated. The court conducted a Nelson hearing and defendant was not seeking to remove Banquets. Banquets advised the court of the 1,000s of pages of discovery, the thousands, not the hundreds, but the thousands of pages in discovery that he had reviewed and organized in his contact of potential use. And he says that all the experts and everybody else that he utilized, Banquets advised the court of defendant's attempts to call him at least 5 to 10 times a day. Banquets further advises efforts to balance the demands of his other clients because I cannot handle multiple clients if I have one client that calls me 5 to 10 times a day. He advised of his efforts to balance those demands because I do have an obligation to more clients than just her. The defense's expectations for communications. In response, defendant reposted that Banquet's representations were untruths, raised Banquet's prior public reprimands for lack of communication. Okay, so he's got reprimands in prior cases, alleged that Banquet's action was the case rose to a similar level, then sought to remove Banquet's. Initially, she said no, and then she said, please remove him. The court pointed out defendant's inconsistent statements within minutes of them being made and addressed concerns over defendant's motivations, especially when there is something that the defendant disagrees with. The court specifically advised defendant that she is not entitled to an endless line of court-appointed attorneys until you find the one that you personally prefer. The court also explained the circumstances where defendant could represent herself. Ultimately, defendant did not request to remove Banquets. Finally, the court denied his motion to withdraw and directed him to have a conference with the defendant prior to the pretrial conference set for January 17th, 2023. It was continued a few times. And finally, on September 8th, a hearing was held on Banquet's motion to withdraw. Defendant was present for the hearing, was sworn. Banquets addressed defendant's derogatory statements, examples, dud, buffoon, and berating behavior. The court advised defendant that the court has received letters from the defendant, some more letters that we've already read after the court's colloquy, I can't even say that word, of defendant. Colloquy, okay. Of defendant and her acquiescence to Banquet's withdrawal. The court granted him his motion to withdraw and appointed Wilson Hobson. And then that's where shit went downhill just a little bit further, because there was a hearing was held on Hobson's motion to withdraw. Hobson addressed a number of issues as for the basis of withdrawing, including disagreements on legal strategy, on what can and cannot be done, a lack of resources, and the defendant's demands make her difficult to work with, including defendant taking non-viable legal positions and being unreasonable. as to key substantive defense. Hobson advised that the retained undisclosed expert is not keeping with what defendant has in mind. The court advised defendant that the court had received a letter from the defendant, another one on the January 2024. The court outlined the overriding claims for withdrawal by Padilla, Bankowitz, Hobson, adversarial relationship, lack of satisfaction, and inability to meet defendants' desires. The court found that all defendants' relationships with all court-appointed counsel have deteriorated such that the defendant and the court-appointed counsel cannot work together. The court advised defendant that although defendant has right to court-appointed counsel, that right is not unlimited. The court has twice advised defendant that the defendant may not be provided another court-appointed attorney. That defendant would have to represent herself if circumstances similar to Hobson's motion to withdraw occurred. The court further advised defendant about the dangers of this self-representation due to the defendant's lack of legal training and knowledge. Defendant never stated that she did not understand that she may not be provided another court-appointed attorney. The court granted Hobson's motions to withdraw and appointed Patricia Cashman, which is what this last letter was about. The court is aware of Cashman's extensive experience representing criminal defendants as both an assistant public defender and in private practice, including representing defendants accused of murder, as is widely known to be able and willing to deal with and manage difficult clients. And if she's able to handle difficult clients, what does that say about this person? On June 7th.
She's crazy.
Yes, but this is where it gets crazier, because on June 7th, 2024, a status hearing was held. She addressed her dates of availability for trial. Defendant was present for the hearing and was sworn. This was the last one that we saw. Thereafter, defendant advised the court to walking out of multiple meetings with Cashman, which was confirmed. Cashman utilizing a pretend judge to oversee defendant and Cashman, launching multiple attacks on Cashman's professionalism and providing the court with letters dated June 4th and June 7th, both of which were filed. Cashman advised to her efforts and spent time on the case so far 20 hours. Now, if you don't understand how an attorney works, 20 hours is a lot of time for an attorney to be spending on your case. Okay, it doesn't seem like a lot, but there's only so much that an attorney can handle in one day. Now, it might be that she works on one case for an hour, she works on another case for another hour. So altogether, she's putting in, easy, 100 plus hours a week. Okay, easy. Billable hours that are can be tracked and traced, and you'll see everything that the work is being done. This is what they should have done with Trump, is provided those kinds of records of the work that was done. But he had an adversarial witness up there that wouldn't do that, or else they could have proven that those were not cash payments made to Stormy Daniels. Those were actual payments done for work. If they would have been smart, they would have sequestered all of his court records of every bit of work that he did. If he didn't do that, that means that he was jacking the prices up or lying about the work that was being performed, which more than likely that's what he did. Lied about the work that was being performed and then took that money, sent it to Stormy Daniels because he was trying to cover for his boss's ass. Don't know, because they never dug into it. Okay, the court advised walking out multiple meetings, blah, blah, blah. Cashman advised her efforts, spent time in the case 20 hours. Cashman addressed disagreements on legal strategy. Does that sound familiar? Including defendant attaching importance to issues that may not be legally important. Okay, now, again, to follow the law. We don't care what you had for dinner yesterday because that is not legally relevant.
No.
How much alcohol you had to drink is not legally relevant. You being an alcoholic is not legally relevant unless you want to have all this stuff sworn into court. In riposte, Defendant accused Cashman of lies and half truths. Cashman moved to withdraw, regulating the Florida responsibility. Irreconcilable differences arise. On June 28th, the hearing was held on the motion, which is the one that we watched on June 28th, 2024. At no time has defendant refused to accept services of any of her 7 appointed attorneys. Now, whenever they're getting into the double digits, that tells you that the judge is really pissed off at this point. Law.
Yes.
And then we're going to go to forfeiture of right of counsel. And here we go. Forfeiture, extreme flows. These are just law portions of it. All right. As set forth above, a reckless of attorneys who were not conflicted out: Padilla, Banquets, Hobson, and Cashman. So there were 4 attorneys that were not conflicted out. The other ones were conflicted out because they were either an attorney for the client, for the decedent, or they were attorneys for witnesses, or because time scheduling just wouldn't work. They might be in trial and they're just like, we get somebody else. And some of those happened pretty quickly. Some of those attorneys out of the 8. Antagonism, hostility, and attacks on the professionalism of Padilla, notably over a year after the fact. And there's a footnote in there about that one, of Banquets and of Cashman, and personal attacks on Padilla, Banquets, and Cashman. Each of the attorneys were required to withdraw. It has become apparent to the court the defendant will not permit herself to be represented by anyone. Additionally, the withdrawal of 8 different attorneys, 7 which were court appointed, leads to the determination that the defendant had forfeited her right to counsel. And this is the declarations, so you can look those up if you want to. As the court finds defendant has forfeited the right to a court-appointed counsel under Florida law, there is no obligation to conduct a Faretta hearing or to otherwise warn the defendant of the dangers because they've already been warned multiple times. The court can find a waiver by conduct to the right of counsel. A waiver by conduct requires that a defendant be warned about the consequences of his conduct, including risks of proceeding pro se, which she has been multiple times. The defendant was advised about the dangers of the self-representation. They were advised in all these different times. As of June 26, 2024, this case has been pending 4 years, 3 months, and 5 days from the date of filing of the information in 2020. Actions speak louder than words, although defendant words seem to reveal the desire to go to trial. However, as set forth herein, her actions and ability to work with court-appointed counsel are repeated over and over, allowing defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage defendant to persist in efforts to prevent the resolution of the case on its merits, the concept of which was first brought to defendant's attention on May 10th, 2022. Defendant complains that Banquets and Hobson failed to meet and communicate when the defendant is provided court-appointed counsel who will meet and communicate Cashman. The ways and means and meetings of communicating are unacceptable to defendant. Orders and the judges as follows. Then this is why I don't know if he's making fun of her, because usually it's adjudicates.
Well, that's what I thought, but maybe he's just like, it's the closest I can do to a middle finger.
Yeah. Cashman's counsel, as condition of Cashman's withdrawal, with Cashman shall provide the court. Okay, this is really cool right here. Shall provide the court an order for costs to obtain transcripts of depositions for 2 witnesses Cashman deposed. Upon completion of the transcription of the depositions, the deposition transcripts shall be sent directly to the defendant, Sarah Boone, by Cashman at the Orange County Jail. Thereafter, Cashman shall file a notice with the court reflecting that the deposition transcripts, they were provided to the defendant. So basically, she's going to file notice that they were provided to the defendant, Sarah Boone, and such notice shall include the date sent and the address of the defendant, Sarah Boone. And you notice they're pointing out the name each time. Defendant Sarah Boone has forfeited her right to court-appointed counsel. Alternatively, defendant Sarah Boone has through waived by her conduct, and I think they put this wrong, has waived through her conduct her right to court-appointed counsel. The trial management conference shall remain specially set for Tuesday, September 24th, 2024 at 1:30 p.m. The case shall remain specially set for trial for 2-week trial period beginning Monday, October 7th, 2024, and will not be continued for any reason except by extraordinarily good cause, and such extraordinarily good cause shall not include retention of counsel by defendant. So if she says, I just got my attorney on October 6th, it will still not be continued. The judge said, no, they're going to have to catch up. We're done playing. Any and all pretrial motions in this case must be filed no later than the close of business on Monday, July 22, 2024. So that's later this month that it has to be done.
She is gonna not know whether to wind her butt or, time her watch. I mean, she's gonna be so freaking confused, and she's just gonna be SOL.
Yeah. She is gonna be in so much pain right now. You have no idea. It is gonna be beautiful. Beautiful, beautiful, beautiful. And it is all her doing. Every single bit of this she could have avoided. Every damn bit of it. But no. She couldn't do that. I have something really cool that we're going to do. Yes, we will stop this at 10. We'll stop this at 10. But I want to show you guys just a little taste of what we've got going on tomorrow. It's going to be glorious. It's going to be wonderful. Give me just a second. I want to give you a little taste. A little taste. So give me just a second.
What it was for. But here's the law, just so you understand why the veto is, and no matter if you overturn it or not, this is still the law. It still would hurt whether they overturn it or not. So they cannot overturn a veto as it relates to Mayor Pro Tem. Even though they did, they can do that because they're gonna.
That is what we are watching tomorrow. That is going to be our story tomorrow. Ooh, it's going to be beautiful. It'll be glorious.
She is such a dumpster fire. Oh my gosh. Even for Chicago standards, I mean, she's corrupt as a $2 bill. I mean, I can't. What is 2024, you glorious shining bastard? Would you stop with the insanity?
We love the dumpster fires. The dumpster fires is where our bread and butter is. Don't you know this?
True, but daggone it.
Daggone it. Why can't they just give me a break for at least a week?
Well, they keep making us look dumb, and I'm kind of pissed off about it.
Well, and that I think there's a lot of people that are pissed off about that, because they've been sitting there going, listen, it doesn't have to be hard to, run your state or your local government well. But they've made it very difficult to do it and do it well. And it makes the ones that are actually good at their job or good at, handling, issues within their community. It makes people get all pissy at them. And it's just like,
Yeah.
These are still human beings, you know.
Yeah, and the sad part is that should another well-qualified, actually wants to do good for the community woman comes up again, people aren't going to she has ruined what could have been a very, very positive thing. And it's gonna make people like, nope, no, we know his corruption, we'll just stick with him.
Yes. And
So the
this
next
is
time,
and this is and it's I say the same thing whenever I was a mechanic. You know, I hated and absolutely despised working with the bad mechanics. The guys that would make shortcuts, or they would lie to the customer to get that quick buck, or they would do things that were shady at best. You know, well, that it'll work. And those guys right there could never understand why I'd be like, no, you're going to fix the problem. No, you're not charging them extra because this is a problem that you created. I'd call them out on it.
yeah,
I was like, you're not charging this person extra because you didn't install the tire properly, and you're going to charge them to reinstall the tire. No, that's not going to happen. Those kinds of things. Or you didn't tighten
yeah,
down the oil filter, and you know you didn't tighten down the oil filter because you told me you forgot to tighten down the oil filter, and now their engine blew. You're going to replace their freaking engine, and it's going to be the cost of the shop. You're not charging them for a new engine after you just replaced the oil filter because you screwed up. You know,
yeah,
because whenever you get people that do corrupt crap like that, it makes me look bad as a mechanic, and nobody wants to come back and see me to do work
yeah.
on their car.
Well, it's just like YouTubers, law tubers, crime tubers, whatever, that rush out with these stories with no care for the facts, no care for, anything other than sensationalizing it. And it then you have to, really say, "Hey, we don't do that here. I will tell you when I'm speculating wildly. I'm a weirdo who wears wigs on the internet." You know, do whatever you want with said information and speculation. But it's people that don't really convey that they are speculating or they don't know. I've never understood the inability to admit you're wrong. I'm wrong a gajillion times a day. Zach catches my grammar stuff all the time. It's not a sin to be wrong. What's a sin is to refuse to do better.
Right.
So I'd much rather have Zach telling me that, Cantonese would probably be spelled with an A instead of an O, just to kind of keep with the thing. I'd much rather him tell me that than look like a moron.
Yes.
I don't
And
know
and
what's so
it,
hard.
and it's the same thing with mine. I do a morning stream where I talk politics, and it's a little more aggressive than some people are wanting for their morning streams, which is fine. I don't expect anyone to be there for it, but whenever I make a mistake and I misstate something, then absolutely, I've been called out multiple times. It's just like, oops, yep, I was wrong on that, but
Yeah.
it's like, okay, let's move on to the next one where I screw up. But if you're only looking for the screw ups, it's the same way whenever I watched the whole election debate. That, I mean, immediately from the get-go, everybody's saying how great Trump is going to, that Biden's going to do, and Trump, Biden's going to look presidential. And by the end of it, they were all just like, that was horrible. He did not look presidential.
Yeah.
But Trump was a liar. And that was their narrative. It's like you're not willing to take any responsibility for your action at all throughout all of this.
No. It's really interesting because that's the interesting thing about trials to me is that you can have all of us watch the same trial and have completely different ideas. And learning how people come with these different ideas, as long as they come in good faith, I'm totally okay with it. It's the
Right.
people and this has been such a weird case in that it has gotten vitriolic and very scary on both sides, when this isn't even a Rittenhouse case, it's not, a
Yeah.
Trump case. It's just very weird how team sporty this whole thing has become.
Yeah.
And I get it. I mean, when you see a miscarriage of justice, that makes people very passionate. But it's this whole inability for people to understand that two things can be true at the same time.
Yes.
You can both think Karen Reed is innocent and still want someone to have an explanation or get some kind of justice for John O'Keefe and their family. They're
Right.
not mutually exclusive. And people go straight to character assassinate. It's just
Yeah. I mean,
assuming that you disagree with me, so bad morals, bad thing.
there's one thing for me to sit there and poke fun at how stupid and ignorant that Sarah Boone is. That if she would have just shut her damn mouth and not given any explanation, but she could not contain herself. She had to constantly talk, and she talked herself into jail. And she continues to make matters worse for herself. And and for everybody else around her. Do I think that what she did in a drunken stupor? Abso-freaking-lutely. But you're still responsible at that point that you're stuffing someone into a suitcase, zipping it up, and allowing them to die. You're still responsible, because if you say, well, because I was drunk, that should be a defense. No, that's not a defense. Just like if you're a drunk driver and you run over a bunch of people, at any point in time, you did not have to take that drink. You could have stopped. You didn't have to get in the car. Anybody could have stopped you, but it's not their fault for not stopping you. Sure, you can go after the bar that was serving you, but you were doing this in your own home. These are things this is a situation you put yourself into, and bad outcome happened. And now you have to face the piper. And it sucks and it's horrible. And I feel for her on that aspect, but she's not helping herself by being stupid. Rant over. Ladies and gentlemen, make sure that you've liked and subscribed to Mo. Give her all the love you possibly can, because
thank you.
I mean, she has the best morning stream. I mean, I talk news, but she talks like no other. She's got the Moisms, and you can't get those from me.
No. And warning for the 2 p.m. stream that I have going over the Epstein grand jury transcripts. It's going to be a little blue. Nothing burns my biscuits, scorches my grits, frosts my flakes, like two prosecutors, basically calling two young minor children ladies of the night and accusing them of trying to extort Mr. Epstein, and then encouraging the jury to also do this during the grand jury. I mean, and these two never faced repercussions. They got to retire. I am big hot mad. So it will be Honey Badger Mo, because
Badger Mo, she's so adorable. She is. She's the best. Honey Badger Mo is the absolute best.
Look, I will be in full F deficit. I'm just telling y'all, like it's going to be, because there is nothing I hate more than the fact that these two girls were then again victimized by the people that were supposed to be getting them justice. It just, whew. Because they maybe didn't have a mom in their lives looking at the broken kind of childhood, but there should be a bunch of mothers everywhere standing up and saying, what the F? And shame. I mean,
big shames.
Yeah.
Big shames. All right, let's end this thing. I'll leave you with one of my old outros. I haven't done it in a while.